I now move on to something that is very close to what I do, that is the legal regime and the courts. Let us briefly examine what the legal regime in our country is concerning education and academic freedom. Article 39F of our Constitution talks of the unenforceable right of a child to be provided by the state opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity. Another directive principle is in Article 45, which originally provided that within a period of 10 years, the state shall endeavor to provide free and compulsory education to all children up to the age of 14 years. In 1993, the Supreme Court of India, in the landmark decision titled J.P. Unnikrishnan versus State of Andhra Pradesh, declared that the right to education is a fundamental right of every citizen up to the age of 14. It took another 10 years for the Parliament in 2002 to insert Article 21 capital A in Part 3 of the Constitution to recognize as a fundamental right the right of every child between the ages of 6 and 14 to free and compulsory education. That, however, was made dependent for its enforcement on a law made by Parliament. Incidentally, this amendment was notified only 8 years later, with effect from 1st April 2010, the same date on which the Right to Free and Compulsory Education Act, the RTE Act, became operational. Correspondingly, Article 45 was amended to the effect that the state shall endeavour to provide early childhood care and education to all children till they complete the age of 6. However, by restricting the fundamental right to education under Article 21A to children between the ages of 6 and 14, the constitutional promise remains incomplete. The judgment in J.P. Unnikrishnan was in a case concerning the malaise of capitation fees being collected for engineering and medical seats in private educational institutions. That problem, however, continues. Two other constitutional provisions that require to be noticed are Article 51 capital A clause H, which states that it shall be the duty of every citizen to develop the scientific temper, humanism, and the spirit of inquiry and reform. Another provision is Clause K of the same Article 51 capital A, which states that every citizen who is a parent or guardian shall provide opportunities for education to his child, or as the case may be, ward, between the ages of 6 and 14 years. Article 25 guarantees to all persons the freedom of conscience, the right to freely profess, practice, and propagate religion. Article 30 recognizes the fundamental right of both religious and linguistic minorities to establish and administer educational institutions of their choice. The High Courts and the Supreme Court engage on a regular basis with numerous issues concerning the right to education, including the admission of students to professional courses, reservation of seats, appointment of teachers and principals in schools, vice-chancellors in universities, anti-ragging measures, recognition and affiliation of educational institutions, and so on. As regards minority institutions, two important decisions in the recent past deserve mention. In November 2024, the Supreme Court recognized the right of the madrasas in UP to run schools providing for religious instruction and imparting education in other subjects up to Standard 12. It did not, however, permit them to award degrees or diplomas. In the second decision, by a narrow majority of 4-3, the Supreme Court held that the Aligarh Muslim University would not lose its minority character only because it stood converted into a university by way of a pre-independence statute. Yeah, thank you. However, these instances do not quite test the court's responses to curbs on academic freedom. Where they do, the result can be disappointing. One such instance has been the judiciary's handling of the cases of students and teachers jailed for protesting against the Citizenship Amendment Act of 2019 and its aftermath. It will be recalled that spontaneous protests erupted not just in Delhi, but throughout the country and even among the Indian diaspora world over. Several hundreds of the protesting students and academics were arrested by the police. Some of them were booked under the repressive Unlawful Activities Prevention Act, the UAPA, for alleged anti-national activity, only to ensure that coming out on bail is next to impossible. 5 years have passed, and with no prospect of the trial in these cases commencing anytime soon, there appears to be no real justification for denying them bail. And now I come to the case of Professor Saibaba. The manner in which the Supreme Court of India dealt with the case involving Professor G.N. Saibaba, who taught English at the Delhi University, has had many a legal scholar express surprise and disapproval. A detailed discussion of the case at this stage may not be warranted, as it is still pending in the Supreme Court. Yet, what we need to know is this. The entire case of the prosecution in support of its invocation of the provisions of the UAPA was that Professor Saibaba was part of a banned terrorist organization, had planned to commit terrorist acts. The case rested entirely on the electronic evidence in the form of CDs, pen drives, and a laptop seized from his residence on 12 September 2013. He was arrested on 9th May 2014. Having been afflicted with polio since his childhood, Professor Saibaba was permanently on a wheelchair. Despite this, bail was refused. It took him 10 years to finally emerge a free person. As was mentioned earlier, on 7th March 2017, the trial court found Professor Saibaba and the other co-accused guilty, but this judgment was overturned by the Nagpur bench of the Bombay High Court on 14th October 2022, more than 5 years thereafter. The High Court held that the proceedings in criminal cases were null and void for want of valid sanction in terms of Section 45, subsection 1 of the UAPA. Literally overnight, and this too was adverted to, literally overnight an appeal was filed by the state of Maharashtra, which was taken up by a special bench of the Supreme Court on the very next morning, which was a Saturday, that is 15th October 2022, in the residence of one of the judges. The acquittal was stayed, perhaps a rare occurrence in the history of the Supreme Court. Professor Saibaba continued, therefore, in the Anda cell in the Nagpur Central Jail, with the Supreme Court being unmoved by his deteriorating medical condition. It took another 6 months for the Supreme Court, by an order dated 19th April 2023, to remand the appeals to the High Court for a fresh hearing. For the second time, by judgment dated 5th March 2024, another bench of the Bombay High Court at Nagpur acquitted all the accused by holding that not only was there no valid sanction to prosecute any of the accused, but that the evidence gathered did not prove the case of the prosecution. Fortunately, in the further appeals by the state against this judgment, no stay was granted by the Supreme Court. As a result, Professor Saibaba could ultimately come out of jail a free man, with his head held high, but his body badly wrecked by the callous treatment he received at the hands of the state during the 10 plus years of incarceration. The process was the punishment. Unfortunately, he did not live long thereafter and succumbed to a post-operative complication after undergoing surgery for gallbladder stones. He was just 57. He was an intellectual whose PhD was on Indian writing in English and nation making. 2 volumes of his writings and poems, while in prison, have been published. The question that troubles one's conscience the most is this: who will be held accountable and when for what the system did to a man of learning and forbearance? Justice appears to have eluded academics and students in the above instances, where they've been accused of being anti-nationals and charged with offences under draconian criminal laws. But then it also appears to elude them when they are the victims at the hands of the non-state actors like vigilante groups and dominant castes. I will make good this comment by referring to the aftermath of the 3 scenarios I referred to at the beginning of my talk. In the first scenario, in the Indore Government New Law College case, it was only in May 2024 that the Supreme Court quashed the FIR against Professor Rahman and his 3 accused after terming the criminal case as absurd. However, Professor Rahman, who was forced to resign, remains uncompensated for the agony and humiliation he has undergone. The others too have not been able to return to the GNLC. This is not an isolated instance. There have been persistent attacks by Hindu right-wing groups on educational institutions across the countries run by Christian missionaries. The priests and nuns are harassed, congregational prayers are disrupted, the land is encroached upon or buildings bulldozed, and some of them falsely accused of indulging in forcible conversions. These cases too are engaging the attention of courts. In the second scenario, the case of the young Muslim boy slapped repeatedly by his classmates at the instigation and instruction of his teacher, that case was taken to the Supreme Court by Tushar Gandhi. The court found egregious violations of Section 17 of the RTE Act, which prohibits any child being subject to physical punishment or mental harassment. The state has been asked to bear the entire costs of the education of the child till he completes his schooling. The case remains at the Supreme Court for monitoring.